Hi, let's talk about the real issue coming out of the recently declassified Nunes Memo. In my opinion, it's perjury on the part of the Department of Justice and FBI officials. The question we have to ask ourselves is, did the FBI and Department of Justice violate federal law when they based any part of their 4 applications for a FISA Court warrant on the Trump Dossier? That was outlined in the Nunes Memo. In my opinion, the answer is yes. I will go through it and let you make up your own mind. 18 U.S.C. 1623 makes it a violation of law, federal law, to make false declarations before a federal court. 18 U.S.C. 1623 states that it is perjury to make a false statement, declaration, certification, or verification to a federal court. A violation shall be fined under this title or imprisoned, not more than 5 years, or both. Proof beyond a reasonable doubt under this section is sufficient for a conviction. In order for the Department of Justice or FBI official to be found guilty of that charge, the government must prove each of the following elements, again beyond a reasonable doubt. First, the defendant testified under oath, in writing, that the evidence supporting the application was true and correct. Second, the testimony was false. Third, the false testimony was material to the matters before the FISA Court. That is, the testimony had a natural tendency to influence or was capable of influencing the actions of the FISA Court. And fourth, defendant acted willfully, that is, deliberately, and with knowledge that the testimony was false. Let's take a look at each element and see if we can satisfy them. First, the defendant testified under oath in writing that the evidence supporting the application was true and correct. In supporting an application for a warrant, the government attorneys must execute the following statement to the court. I declare under penalty of perjury that the foregoing is true and correct. That must have been done. Second, the testimony was false. The Nunes Memo states that the dossier, compiled by Christopher Steele on behalf of the Democratic National Committee and the Hillary Clinton campaign, formed an essential part of the FISA application. The Trump dossier submitted with the FISA application contained a number of pages that referenced, and I'll quote, Kremlin Insider reports Trump lawyer Cohen's secret meetings with Kremlin officials in August 2016 were held in Prague. Another quote, Kremlin Insider outlines important role played by Trump's lawyer Cohen in secret liaison with Russian leadership. Now pages 18, 19, 30, 32, 33, 34, 35 of the 35-page dossier contained references to Mr. Cohen. A check of Mr. Cohen's passport will show that he had not been to the Czech Republic. If he has ever been to the Czech Republic, he could not have been in Prague, as the dossier stated. Mr. Cohen has also stated that he has proof of being in other locations during the time specified in the dossier. The FBI, in verifying the truth and accuracy of the dossier, which they submitted to the FISA Court, must have verified whether or not Mr. Cohen was in Prague in August of 2016. So they knew that at least 8 pages of the dossier had an untruthful information. So the Department of Justice and FBI falsely testified that this evidence was truthful and verified. Third, the false testimony was material to the matters before the FISA Court. The false information was material to the matter before the FISA Court. It was designed to impact the decision of the FISA Court and for the FISA Court judge to rule in favor of the government. And fourth, the Department of Justice and FBI acted willfully, that is, deliberately and with knowledge that the testimony was false. The Department of Justice and FBI knew that at least 8 pages of the dossier contained untruths, but they still told the FISA Court that the evidence was truthful and correct. In my opinion, the elements of perjury have been satisfied. The Department of Justice and FBI are tasked to uphold the rule of law. Any compromise in this cannot be allowed. Those responsible for these actions must be held accountable. A grand jury must be impaneled, and all violations of law presented to the grand jury for possible indictments. Well, I hope this helps. Have a good day.